You are listening to South Dakota Public Broadcasting's live webcast service on the South Dakota Network. More information at sd.net.
There's like this perfect distance you have to be away from ours. If you're a little too far away, it doesn't pick you up. If I get too close, it sounds like I'm screaming at everybody.
That's how I should be speaking.
Can you hear me?
Yes, we can. Oops. Yes, we can.
Okay. Thank you.
Yeah, everybody ready?
Good morning, my name is Michael Smith. I'm the chairman of the South Dakota Open Meetings Commission. It is 10 a.m., the time that this meeting is set to begin. I want to welcome everyone who is attending today's meeting. I have a few housekeeping items before we take roll call. This meeting is being held in person and peer and remotely via Teams. For the benefit of all listeners and participants, I ask that any speaker, including commission members, identify themselves when speaking. This meeting is also going to be recorded. The Teams recording will be posted on the Open Meeting Commission webpage in the near future. South Dakota Public Broadcasting is also posting it. Please mute yourself unless you are speaking, commissioners. And for those who wish to make a public comment, please identify yourself and spell your name for the record. Having addressed those items, I would like to ask Ms. Kotz to call the roll to establish a quorum of commissioners.
Chair Michael Smith.
Present.
Austin Hoffman.
Present.
Caitlin Hoffman.
Present.
Emily Savitt.
Present.
Lance Russell. Lance Russell. Maybe you have to unmute yourself. Is he on the?
You can see him on the bottom right.
Try one more time, Lance. We know you're there. Lance Russell, we want to make sure our equipment's working. Okay, we'll give you, keep trying. We haven't heard anything yet. We'll let you know when we hear you. We still haven't heard you. How do you want to handle it?
We have a quorum. We see that he's present. Let's continue, and if hopefully Lance will avail himself to us and availability. Anybody have any dispute with that?
Okay. And there are guests appearing remotely. I would have you state your name.
Rachel Hinsvark.
Thank you, Rachel.
Megan O'Brien, South Dakota Searchlight.
Thank you, Megan.
I see Mr. Russell just jumped off here, so he must be having issues.
Gary Kaufman, are you still on?
Yes, Gary is here.
Thank you.
looks like there's a individual from the city of Gary indicating they do not have a microphone
Okay.
in the chat as well. Okay. There is a quorum at this point, so it'd be my intention to continue forward.
Okay, so there is a quorum, I'll turn it back over to the chair.
Thank you. The first item on the agenda here is approval of the agenda. May I now have a motion to approve?
So moved, Hoffman.
Second, Sobel. Second, Sobel.
Understood. We have a motion and a second. All those in favor of the motion, please indicate by saying aye. Aye.
Aye.
Any opposed? Motion passes. Item number 2 is conflict of interest. Is there anyone on this commission that has a conflict of interest that they need to make the commission aware of at this time? Hearing none, we'll move to agenda item number 3. It's public comment period required by South Dakota law, SDCL 1-25-1. We invite any members of the public to provide comment at this time. We will limit public comment to 5 minutes, and I would ask Ms. Kotz to keep track of the time. Does anyone appearing in person wish to give public comment? Seeing none, does anyone appearing remotely wish to give public comment? Okay, as there is no public comment, we will proceed with the next agenda item. Agenda item number 4 is approval of the meeting minutes of the Commissioners' November 3rd, 2025 meeting. Concerning the November 3rd, 2025 minutes meeting, does anyone have any corrections to note? Hearing none, may I have a motion to approve the minutes?
Hoffman, so moved.
Is there a second?
Sobel will second.
All in favor, please indicate by voting aye.
Aye.
Any opposed to the motion, please indicate by voting nay. Motion passes. We'll now move to agenda item number 5, which is the approval of the finding of facts and conclusions of law in the matter of the open meetings complaint 2025-03 from the Rapid City Area School District concerning the finding of facts and conclusions of law in this matter. Does anyone have any corrections to note? Hearing none, may I have a motion to approve the findings of facts and conclusions of law?
Moved by Sobel.
Is there a second?
Second.
Alright.
The other Hoffman seconded that.
She beat you to it. We have a motion and a second. All in favor, please indicate by voting aye.
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 Any opposed indicate by voting at this time. Motion passes. We will now move to agenda item number 6, which is approval of the finding of facts and conclusions of law for the matter, in the matter of open meeting complaint 2025-04, Green Valley Sanitary District. Concerning the finding of facts and conclusions of law, we did receive a statement from Mr. Kaufman regarding that. It was my understanding that this was delivered to the Attorney General's office this morning. The 4 commissioners sitting here present were able to have been provided this document, which has been completed by Mr. Kaufman. Mr. Kaufman, would you like to make a statement on this? Would you like me to read it out loud? How would you like to have this addressed?
Thank you, Chairman Smith. I'll just make a couple comments. I wasn't even sure if I had standing, so that's why I chose not to do it in public forum and sent it to the AG's office instead. I guess just simply because I have worked for a number of years and continue to work with political subdivisions and, very much follow the open meetings laws, and the requirements in OMC decisions. The wording in the Green Valley conclusions caused me reason to pause because the language in there, as I indicated in my letter number 4, language says the motion must clearly state the specific purpose or legal basis authorized under the statute. And in 6, it talks without, where the Board of Trustees went into exec session without stating an authorized specific purpose or legal basis. And I was just concerned about the wording in those conclusions, because the statute talks about, the public body has to cite a specific law, okay? And so when you're talking about must give a specific purpose or legal basis, I'm just concerned about that could cause some confusion, because it's not the specific law, the statute. And as I indicated in my letter as well, the Attorney General's brochure on open meetings, specifically in response to a question, what's the proper procedure for exec session, is that for a sentence in the answer, motions for exec sessions must refer to a specific state or federal law allowing for the exec session. And so I was just concerned about the wording, in the proposed conclusions there, about referencing a specified or a specific purpose for legal basis, as compared to what the law says, it says a specific law is cited. And I just wanted to make sure that my thoughts on that issue were made aware, because for people like me who read your decisions and your findings and conclusions, I just think it raises a question, I guess is what I'm trying to say. And I just wanted that to be known. So I thank you for your time. I'll answer any questions you may have.
Thank you, sir. Concerning the finding of facts and conclusions of law in this matter, does anyone on the commission have any corrections to note?
This is Commissioner Sobel, and I don't disagree with the comments that were made. I'm not sure on the standing issue. However, the law says what the law says. We have, I'm not going to say that we. I have been to a number of meetings through the years where there has been reference to the reasons within the statute, or said with regards to an employment issue or employee issue that complies with the statutes. And I suppose it's a case-by-case basis that we address those to say whether it was articulated sufficiently. So I'm okay with how it's stated, but understand that we are not in absolute form of mimicking the state law.
Any other comment from the commissioners?
This is Austin Hoffman. I'm okay with the way it's stated, but I also understand where the concern is coming from. It wouldn't be difficult to change that wording to something along the lines of must clearly cite the specific law, or stating an authorized specific law to what it is, change it to get that specific law wording in there instead of the specific purpose or legal basis. Or maybe just take out purpose and leave legal basis.
And for what it's worth, Mr. Kaufman's recommendation pursuant to his letter is to just make it say the specific law.
I think the language for purpose is coming from 125.2, where it says the executive or closed meetings may be held for the sole purposes of, and then it lays out those subsections.
I would make a motion to amend conclusion number 4 and conclusion number 6 to delete the specific purpose for and just state legal basis.
Hoffman's gonna second that.
All right, we have a motion and a second. Any further discussion on this, given that this is an amendment to the proposed?
I just want to comment that I don't think it was necessarily inaccurate. I understand why the motion and second were made, because I think that covers the statute where it reads the sole purpose, but I just wanted to make that clear.
And I see Mr. Russell is present now. Are you able to hear us all right?
Yes, I am. Thank you.
And we did note your presence at the time that we took roll call. We just knew we couldn't hear from you.
Yes, and thank you for that. I did hear that.
Okay, any further discussion on this motion? Hearing none, all in favor indicate by voting aye. Those
Aye.
opposed? Motion passes. Okay, and we'll move now to agenda item number 7, which is consideration of procedure. We have 4 complaints, and an overview of the procedure for each complaint is as follows. Ms. Kotz, do you want to provide some details on what you're, on this agenda item number 7? I know we have 15 minutes per complainant and respondent, is that correct?
That's correct.
And there is a rebuttal that's allowable within the 15 minutes of the complainant, so if a complainant would like to reserve time for rebuttal at the end of the respondent's claim, we also allow for that, correct?
Correct.
And that has been the standard procedure. We do have, not agenda item number 8, but the following, not 8A, but 8B, C, and D, there are some stipulations that have been drawn up. We'll deal with those when we get there, rather than now?
Yes.
Okay. Then at that time, this time we'll move to agenda item number 8, which here is the consideration of the pending complaints. We will first handle item number 8A, which is titled in the matter of open meeting complaint 2025-05, Town of Hermosa. The complainant is Vicky Henriksen. Is Miss Henriksen present?
She indicated to me that she was going to appear remotely.
We, in the past, when we've had known that people plan to attend, I think it's been pretty standard that we've moved on and handled other business in anticipation of them perhaps running late or not understanding the time that this meeting started. Does that, anyone on this commission have any issues moving to 8B at this time and circling back to this?
Is there anybody here for the city of Hermosa?
Is Mr. Scott James appearing remotely?
Yes.
Who is that?
Rachel Hinsbark.
Nope, we're not quite to your matter, Rachel. We're looking for Vicky Hendrickson right now.
My apologies.
Nope, that's fine.
I think so long as there's nobody that's lingering or has scheduling issues with the city of Hermosa, just moving on to the next businesses.
All right, I agree. At this point then, it'd be my intention, given that neither the complainant or the respondent appear to be present at this time, we're going to move to agenda item 8B. 8B is, at this time, it's complaint 2026-01, City of Gary City Council. And I'm going to turn this back over to Ms. Kotz at this time.
Thank you. Beverly Katz, the city of Gary is represented by Reed Melke, and he was offering a stipulation and agreement with reprimand to handle OMC 2026-1, the very first complaint regarding the city of Gary. And at this time, I'm going to read the stipulation and agreement, and then I believe that Rachel Hinsbark would like to address the commission. So I'm going to start reading. Stipulation and agreement. The stipulation and agreement with reprimand is made and entered into by the South Dakota Open Meetings Commission, hereinafter referred as OMC, and the city of Gary, governed by the Gary City Council, hereinafter referred to as the Gary City Council, witness and agree to the following. Number 1, on December 4th, 2025, Rachel Hinsbark mailed alleged violation of the open meetings laws by the Gary City Council to the South Dakota Attorney General In accordance with SDCL 125-6, the complainant must be directed to the attention of the local state's attorney. Number 2, on December 17, 2025, the South Dakota Attorney General's Office staff referred the complaint to Dual County State's Attorney Craig Evenson for an investigation and for action pursuant to SDCL 125-6. Number 3, on February 17, 2026, Dual County State's Attorney Craig Evenson referred the alleged violation to the open meetings law to the Attorney General's Office for the Open Meetings Commission to hear the matter in accordance with SDCL 125-6 subsection 3. Number 4, the complaint alleged that the December 1st, 2025 Gary City Council meeting, the council went into executive session for personnel and legal matters. Number 5, the complainant alleges that 3 city employees were present in the executive session without a recorded motion or vote authorizing their presence. And with that, after being dismissed, am I on the right one? Okay.
Yep.
1 employee remained within earshot of the executive session, potentially overhearing confidential discussions. Number 6, the complainant further raises concerns about a local conflict of interest affecting the impartial review of the matter at the county level. Number 7, the Gary City Council understands that they have a right to consult with an attorney of their own choosing and expense, and did so with Counsel Reed Malky. The Gary City Council understands they have the right to an administrative hearing. City Attorney Reed Malky and Mayor Larry Stocks have been authorized to sign the stipulation in the agreement and is waiving the board's right to a hearing based on authority and consent. 8, the Gary City Council admits to an open meetings violation, and they acknowledge that confidentiality of an executive session could have been breached at the December 1, 2025 Gary City Council meeting. 9, the Gary City Council will use its best efforts in the future to ensure individuals will not be allowed within earshot of an executive session. 10, a copy of the open meetings brochure dated December 31st, 2025 will be provided and explained to the Gary City Council by City Attorney Reed Malky at a future meeting within the next 60 days. Number 11, the Gary City Council, as the governing body of the City of Gary, South Dakota, is a public body subject to the open meetings requirements of SDCL Chapter 1-25. 12, the Gary City Council admits, and the Open Meeting Commission concludes, the Gary City Council did violate the open meetings laws by not safeguarding against individuals being able to possibly overhear the confidential portion of the executive session at the December 1, 2025 Gary City Council meeting as required by SDCL 1-25-2. 13, it is the intent of the Gary City Council to provide an offer of an informal compromise and settlement of all issues which could be raised in a formal contested hearing. 14, this stipulation and agreement is a public record of the Open Meetings Commission and shall be published on the Open Meetings Commission website. 15, in the event the Open Meetings Commission does not approve of this stipulation and agreement, any argument is waived that the Open Meetings Commission members considered this stipulation and agreement should be disqualified from later rendering a decision in any subsequent contested case hearing regarding this pending action. 16, the Open Meetings Commission does not have jurisdiction over local conflicts of interest affecting the impartial review of a matter at the city level. Number 17, findings of facts, conclusions of law are hereby waived. Dated this date, I don't have the date. 27th of April 2026, signed by Mayor Larry Stokes and signed by Reed Malky, attorney for the City Council.
And to be clear, it appears that's the 23rd is when they signed it.
Okay. The 23rd of April is when Mayor Stokes and Reed Malcolm signed it. The reprimand, based on the following, the South Dakota Open Meetings Commission reprimands the Gary City Council for violating SDCL 1-25-2 by failing to safeguard against individuals being able to possibly overhear the confidential portion of the executive session at the December 1, 2025 Gary City Council meeting. And the rest is a vote and decision. So I will turn it back over to Chairman Michael Smith.
Thank you, Ms. Kotz. From indicated, I do believe Ms., is it Hinsvark, Rachel Hinsvark? Are you present via Teams, correct? And would you like time now to speak and address the commission regarding the stipulation at this time?
Okay, good morning, and thank you for the opportunity to speak.
And
I want to begin by acknowledging.
Ms. Hinsvark, I will just remind you that there's the time allotted for this will be 15 minutes, and will you, Ms. Kotz, will you please keep track of that and inform Ms. Hinsvark when there's 5 minutes remaining on her 15-minute timer?
Yes, thank you.
Thank you. All right, you may begin. My apologies.
No, thank you. I want to begin by acknowledging and appreciating that the Gary City Council has taken responsibility for the open meetings violation. That step matters, and it's important for maintaining public trust. However, I do have concern regarding the stipulation as it currently stands. While responsibility has been accepted, there's no mention of what specific measures will be put in place to ensure this type of violation does not happen again, particularly when it comes to non-board members being present or listening when they should not be. I understand that there is no South Dakota state law that specifically requires a vote on who is permitted to be present during executive session. However, the Gary City Council has adopted Robert's Rules of Order, newly revised, for conducting its meetings. As stated in that authority, an executive session is a meeting or portion of a meeting in which proceedings are secret. Only members of the body have the right to attend. Others may attend only by permission of the body. This makes it clear that the presence in executive session is not automatic, must be intentionally allowed by the governing body, and there should be a clear understanding of who is present and why. To address this moving forward, I would propose a simple and practical solution when the council enters into executive session. Any non-board members, including Ms. Sheldon, who is listed in my complaint, and other city employees should vacate the building unless they have been expressly approved to remain. This creates a clear, consistent standard, removes any ambiguity, and helps ensure this type of violation does not happen again. These are straightforward steps that help protect the integrity of the City Council and rebuild public confidence. Thank you for your time and consideration.
Thank you.
I'm done.
Understood. Thank you, ma'am. Just for clarity, is anyone from the city of Gary present? Okay.
I thought Joni, the one that can't speak, was the finance officer for the city of Gary.
I believe that that's correct. Ms. Jeldon or Joni, and you're correct, I do see there it says she does not have a microphone. Is there any record you would like to make, understanding that you don't have a microphone? We could facilitate a phone call into this room if there's anything on behalf of the city of Gary, anyone, including yourself, that intends on making a statement on behalf of the city of Gary. Oh, and I see he or she has indicated in the chat, no thank you. And seeing no one else present from the city, I'm now going to open this first, we're dealing with 8B here, this complaint up to the commission for the conduction of deliberations.
This is Austin Hoffman. While I certainly appreciate them putting together a stipulation and agreement with the reprimand in there. I don't believe we as a commission necessarily have the legal authority to enter into a stipulation and agreement. I personally, just so it fits with everything we've done in the past, would like to see kind of our standard findings of fact and conclusions of law and all that put together for this and voted on by us at a later date. I certainly think we can use what they've done here for that. I mean, in all reality, it's you could kind of view it as a signed admission, more or less. We've got the majority of what would be needed there already, but again, as a board, I don't think we have the authority to enter into something like this.
I would agree with those comments as well. This is Commissioner Sobel.
Any further discussions from the board? Hearing none, is anyone inclined to make a motion at this time?
Hoffman will make a motion to find that there was a violation based on the stipulation and agreement, and that the stipulation agreement would be used to put together a findings of fact and conclusions of law.
We have a motion, any second on that motion?
I will make a comment. I'm not going to second at this time. I'm just wondering if it's appropriate to base it on the stipulation, or if we simply find that there is a violation and certainly I think we could use some of the information from their admission, but I don't know that we say specifically we base it on the stipulation.
I have no issue with that. Since I don't have a second, I think I can just ultimately remake my motion at this point. So I will change the motion just to find that there has been a violation and that the stipulation agreement can be used to make findings of fact and conclusions of law for that.
Sullivan, second.
We have a motion and a second. Any further discussion? Hearing none, all those in favor indicate by saying aye.
Aye.
Those opposed? Motion passes. Thank you, Ms. Hinzvark, for your appearance today. We're now going to move into the next matter. Has anyone joined the meeting at this time?
I have a hard time seeing how far it is. If there's someone that has joined the meeting, please state your name.
Okay, hearing none, I believe C and D will likely also move fairly quickly. Let's just move to C, and then as long as we're timely on that, we'll move to D, and then we'll circle back to 8A at this time. So at this time, we're going to move forward to C, 8C, which is complaint 2026-02, City of Gary, City Council. We do have additional stipulations and agreements. Let's work through those in the same way we have before on 8B. So at this time, I'm going to turn it back over to Ms. Kotz.
Thank you, Beverly Cox. Stipulation and agreement. This stipulation and agreement with reprimand is made and entered into by the South Dakota Open Meetings Commission, hereinafter referred to as OMC, and the City of Gary, governed by the Gary City Council. Did somebody want to announce that they had just joined? Okay.
Hello, this is Craig Evenson calling in.
Thank you, Craig. Okay, I am just on the first paragraph of the stipulation agreement with reprimand. Referred to as the Gary City Council witness and agree to the following. Number one, on February 17, 2026, Dual County State's Attorney Craig Evenson acted in his capacity as State's Attorney and acting in his individual capacity as the complainant referred an alleged violation of the open meetings laws to the Attorney General's office for the OMC to hear the matter in accordance with SDCL 1-25-6 subsection 3. Number 2, the complainant alleged at the time designated as public comment period, 3 members of the public who were also city employees were asked to leave the November 3rd, 2025 meeting by the Gary City Council. Number 3, the Gary City Council understands they have a right to consult with an attorney of their own choosing and expense, and did so with the council attorney Reed Melky. Gary City Council understands they have a right to an administrative hearing. The attorney Reed Melky and Mayor Larry Stokes have been authorized to sign the stipulation and agreement and is waiving the board's right to a hearing based on their authority and consent. Number 4, the Gary City Council admits to an open meetings violation related to removing from the open meeting 3 members of the public who were also city employees at the November 3rd, 2025 Gary City Council meeting. Number 5, a copy of the open meetings brochure dated December 31, 2025 will be provided and explained to the Gary City Council by City Attorney Reed Melky at a future meeting within the next 60 days. Number 6, the Gary City Council, as the governing body of the City of Gary, South Dakota, is a public body subject to the open meetings requirements of SDCL Chapter 1-25. 7, the Gary City Council admits, and the OMC concludes, the Gary City Council did violate the open meetings law by failing to allow members of the public to remain during the open meetings portion of the November 3rd, 2025 Gary City Council meeting as required by SDCL 125-1. Number 8, it is the intent of the Gary City Council to provide an offer of an informal compromise and settlement of all issues which could be raised in a formal contested hearing. Number 9, the stipulation and agreement is a public record of the OMC and shall be published on the OMC's website. Number 10, the stipulation and agreement is subject to OMC approval. In the event the OMC does not approve of this stipulation and agreement, the OMC will proceed to hear this matter, and any argument is waived that the OMC members considering this stipulation and agreement should be disqualified from later rendering a decision in any subsequent contested case hearing regarding this pending action. Number 11, findings of facts, conclusions of law are hereby waived. Dated this 23rd day of April 2026, signed Mayor Larry Stokes and Reed Melky, attorney for the Gary City Council. The reprimand paragraph reads as follows: based on the foregoing, the South Dakota Open Meetings Commission reprimands the Gary City Council for violating SDCL 125-1 by failing to allow members of the public to remain during the open meetings portion of the November 3rd, 2025 Gary City Council meeting. And then it's just language for voting and appearance. I will turn it back over to Chair Smith.
All right, Ms. Cox, thank you. It is, given how we just handled 8B, it'd be my intention at this time to open the oral presentations. The complainant is State's Attorney Craig Evanson. Mr. Evanson, are you present at this time?
I am present.
Would you like to make an oral presentation? It will be limited to 15 minutes, including a portion of that time being reserved for rebuttal.
Just a quick, I don't think I'm going to have anything different actually to say than the city, but I'm just going to walk down the facts. So there's an audible record of this at this hearing. Does that sound fine?
Yes, sir.
Okay. And I got to make sure I got my materials I have the two and only one I'm on the, and the only one I'm the complainant on. The, report in that situation, our sheriff, conducting an investigation of the, situation before us. The outcome was that, 3 individuals were excluded from from a meeting, in open session. I don't think those facts are in dispute. It sounds like the city is looking to admit those facts. I listened to the, discussion of the stipulation agreement and a reprimand, and that would be agreeable from the state, as far as, representing the voters of Dole County. And that'll be all I have for you, Rick.
Thank you, Mr. Evans.
Okay.
Any questions from the commission, to Mr. Evanson at this time? Hearing none, anyone from the city of Gary, city council present and would like to respond? Hearing none, and not seeing any statement by Ms. Jeldon at this time, I'm going to open this matter up for deliberations with the commission.
I would ultimately make the same comments I did for the last one regarding the city of Gary. This is Austin Hoffman. While I certainly appreciate the work being done to put together a stipulation and agreement with the reprimand in there, I don't believe as a board that we have the right to enter into that. And we should probably move forward with findings of fact and conclusions of law if we do so vote that there is a violation here.
It does almost sound like a motion. Any further discussion, or is anyone inclined to make a motion?
I'm going to make a motion in a second here, but before I do that, I also want to state that I think we may have gone through Gary 1 a little too quickly. I'm not so sure there's a violation there, to be very honest with you. I think we have to go back and take a look at that.
I actually agree with that comment, but with an admission to something in writing. Let's finish this motion and then we'll circle back.
I would agree.
Discussion.
Regarding Gary 2, the item before us, Hoffman would make a motion to find that there was a violation and that the findings of fact and conclusions of law should be drafted with the help of the stipulation agreement with reprimand offered to the board.
I will second that motion.
Okay, on what we've referred to as Gary 2, the second complaint, 8C, which is 2026-02, just for clarity since we were discussing the other one. We have a motion and a second. Any further discussion from the commission? Hearing none, all those in favor indicate by saying aye.
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 Those opposed? Motion passes. Ms. Kotz, as Mr. Hoffman alluded to, he'd like to have an opportunity to go back to Gary 1, which was complaint 2026-01. We're still within the meeting. We did have a motion. We voted on that motion. We're still inside of the same meeting in which that business took place. I believe we have the authority to go back and reconsider that. Do you have any position on that, or does anyone on this commission have any position on that beyond what was already kind of discussed?
This is Beverly Kotz, counsel for the Open Meetings Commission. I believe you still have authority and it's flexible enough where you can go back and revisit.
Then at this point, since the city, those that are interested in this, from both sides likely are still on this call, let's go back now to 8B, and Mr. Hoffman, you have a statement that you would like to make as it relates to the motion that was passed.
in the interim here, I've looked through some statutes and reread the stipulation and agreement that was offered to us for Gary 1. And while I can understand the concern of having other people in executive session, I don't find a statute that says they cannot be. I have always been of the opinion that if a commission or a council or whatever it may be goes into executive session and they want outside people in that executive session with them, they absolutely have the right to do that. If they didn't ask them to leave, that's almost could be viewed as an assumed agreement or assumed permission for those people to be in that meeting. So I don't necessarily know if that's a I don't think it's a violation that the other three people were in there. I can, like I said, I understand the concern, but as far as an actual violation goes, I don't find in the statutes, and maybe there's something I'm missing, certainly point it out if there is, but I don't see in there where it would be a violation. Regarding the somebody within earshot of executive session, again, you know, I think the board has an obligation there to make sure people can't hear that, but I'm not finding anything in our statutes that says they absolutely have to. You know, you can't control everybody all the time, so I, again, understand the concern, but I'm not finding where it would be a direct violation of our open meeting laws.
I don't disagree with you, and I was basing it on their admission, but you can't allow someone, by way of analogy, to plead guilty to a crime that they have not committed, so therefore should they be able to plead or admit to and have us accept a violation that is not technically a violation.
And actually, as I worked through this, I was unaware of the stipulations until this morning. I missed that email. But as I worked through these, you know, I was under the same opinion that, you know, I think what we're discussing here is perhaps an area where we're missing. You know, is this something that should be inside a statute? I don't think it is either. I was with you though, the fact that they had essentially signed off on this, they had signed off on the stipulation and agreement, led me to say we could move forward, but as Mr. Hoffman stated, what sort of precedent are we setting by finding a violation here if it's not found within law? I agree that 125.2 does not prohibit the behavior necessarily, and I think Mr. Hoffman did a great job of pointing that out and rationalizing why.
No, I think it's right to reconsider this as I look at the many meetings that I've attended. How many times do we say, oh, employee X, you need to remain because this pertains particularly to an issue you were involved in, or it pertains to your employment, or it pertains to you as the record holder of those documents.
Or department head.
Or department
Right.
head.
Personnel matters.
Yep.
So as much as I was basing it on the admission itself, I think we're right to revisit it and not create a bad precedent for future files.
At this time then, we do have, we've passed the motion. I think at this point, Ms. Kotz, do you have a preference on how we go about reworking this?
I think on Robert's rules, you have to motion to.
I believe I have to make a motion to rescind my previous motion regarding finding a violation, and then the same person that seconded my original motion has to second that one, and then we vote on it.
I'm in agreement with that procedure, and I am willing to do the same if you make that motion.
I will, this is Austin Hoffman, I will make the motion to rescind my previous motion that found a violation for the city of Gary in what we are considering Gary 1.
And I will second that as the individual who had seconded the motion originally.
Okay, any further discussion from the board in regard to this now motion to rescind?
The only question that I would have, this is Mr. Russell. I'm kind of curious as to Ms. Katz's rationale for the stipulation as it relates to finding of the violation. I don't think that we've heard from her yet on the rationale for the violation.
The complainant, Beverly Cox, the complainant, Rachel Kinsmar, is that who you're talking about?
I'm having a hard time hearing her.
The complainant, let me just grab a mic. The complainant, Rachel Hinsmark, had indicated that in her complaint and just in the materials that somebody was sitting outside the door of the executive session. Is that the one we're talking about?
Correct.
And all others had left the building. And so that was the basis of the complaint, that it wasn't truly a closed, a confidential, if somebody could overhear what was going on. Thank you.
So a further question, Mr. Chairman, if I might.
Yes.
So Ms. Katz, as you review the statute, is it your opinion that the statute also does not require that the meeting that was held there in retrospect was not a violation of the statute?
Okay, so if you're asking me if the meeting that was held in executive session 125-2 was a violation or not, the complainant indicated that there was a violation.
My question for you, and Mr. Chairman, if I might, is in retrospect, as you look at the statute, do you believe that there was a violation?
This is Emily Sobel speaking. I'm a little concerned that if our legal counsel tells us it's a violation, it's taking it out of our, essentially taking our jobs away and putting in the opinion of our counsel for the decision that we're making. As much as we rely on her heavily, I don't know that we should go down that road.
Can you hear her, Mr. Russell?
I could not hear any response to my question, no.
I'm sorry, this is Emily Supple again, and I don't want to go down a road where we rely on our legal counsel to usurp the responsibility of the commission as a whole to make that decision. I'd love to have her make that decision, but I'm a little bit concerned that if we pass the determination onto our legal counsel, we're heading down an interesting path here.
I agree.
Yeah, and that this is Mr. Russell again. Mr. Chairman, the reason that I ask is that we have a stipulation that was drafted by our counsel that there was in fact a violation, and it was also agreed to by the attorney for the city, and we have a signature as such. I understand that ultimately the decision is ours. However, I was just trying to get to whether or not there was any, in retrospect, if our council now believes that that may have been, that there may very well not have been a violation.
I think maybe we should make one point of clarification. I believe the stipulation was actually drafted by, not by our council. It was submitted for review, correct?
It was a combination of both. I drafted and he reviewed, yes.
Okay, I'm sorry, I misunderstood that.
And I didn't hear her response.
She said it was a combination, that she worked with council in preparation of it. I misunderstood. I thought it was submitted for our consideration by council, not our council, I should say.
I guess I don't believe that when Ms. Kotz was involved that she was necessarily picking one side or the other. Rather, she was just reviewing the language to ensure that it covered what it needed to for us to consider. So I don't think there really was Ms. Kotz leaning one way or the other.
And I think that's fair, and I think we have to interpret that as such, and I'm not gonna, I'll let the chairman take over the position of whether Ms. Kotz should describe anything further, but I think that's fair.
I believe it's fair as well. At this point, we're still in the discussion portion. We have a motion to rescind. Is there any further discussion at this time concerning the motion to rescind? Hearing none, all those in favor indicate by saying aye. Aye.
Aye.
Those opposed?
Can I be?
No.
One moment, ma'am. All those opposed?
No.
With an indication of no, is it proper to do a roll call at this time?
We have.
Ms. Kotz, I believe so as well. So I'll turn the floor over to Ms. Kotz for a roll call.
Roll call vote. Michael Smith,
Aye.
Austin Hoffman,
Aye.
Caitlin Hoffman,
Aye.
Emily Sawville,
Aye.
Lance Russell.
No.
Thank you.
Thank you. Motion passes. And is that Ms. Hensvark? Is that were you trying to speak during that?
Yes, I apologize.
So Ms. Hensvark,
Can I have
it's now that the motion has been rescinded, we did provide you an opportunity to be heard, but it was really on the stipulation. It'd be at this point, it's my position that I'm gonna open the floor back to you for oral presentation. I'm gonna give you that 15 minutes allotted to discuss this. Essentially where we're at now is the motion has been rescinded. So the intention of this commission will be to ultimately make another motion on this matter and then vote again. But in fairness to you, given where we were at with the stipulation language, I want to give you the opportunity to be heard prior to that discussion and ultimate vote again. So Ms. Hensvark, at this time as the complainant, you'll have 15 minutes, including the rebuttal time. Ms. Kotz, will you please let her know in 5 minutes remains on that to provide any additional information you'd like us to hear, ma'am.
Okay, so my complaint is with the city council for not securing the area, and with Joni Sheldon, who is the city finance manager. She's not a board member, but when she was asked to leave executive session, she sat directly on the other side of the door. There's a hallway and there's a bathroom. In the hallway, somebody went in to use the restroom and saw Joni sitting directly on the other side of the door. Can you hear me?
We can. We've suddenly picked up an echo that you didn't have a second ago, but now it's very present.
Hold on. Is the echo gone now?
It is.
Okay, sorry about that. So Ms. Sheldon knows the rules of executive session, and she knows that she should not be sitting on the other side of the door. And that is my complaint, because how many executive sessions has she been listening into when she was not supposed to be there? That's where my complaint comes in. The public is asked to leave the building, and she never actually leaves the building. I just wanted to clarify that for you.
Understood. Thank you, ma'am. Anything else you would like to add?
I don't think so.
Okay. Does anyone have any questions for Ms. Hinsvark from the commission?
Is there any indication that the body, the governing body, was aware or had invited or solicited her in a proximity where it was, she could hear what was going on?
That the governing body was allowing her to sit there? Is that what you're asking?
Or that they in any way solicited her to be within earshot of their executive session?
No, I believe she was asked to leave at that point.
Any other questions from commissioners?
I guess maybe just to clarify, when your city holds your open meeting, is it at the end of the meeting, they're gonna hold an executive session, they ask the entire group to leave, but yet they would still have to, I guess my point is, they would still have to come back at some point to then end the meeting, and typically, the finance officer is the one who keeps the minutes, so I'm just wondering if that would be a reason why they're perhaps sticking around or.
Right, and a lot of times there's a public motion made immediately following those executive sessions, and as the record keeper, right, they're very often nearby, and so I think it's very hard to find that the body, the governing body itself, was violating anything within the open meeting rules under those circumstances.
Would you like to?
I could understand if she went further back into the building, but sitting directly on the other side of the door to listen to what they're talking about. In the past, I think that one of the board members has went further back into the building to get her when they call the public in and close the meeting.
So, and I think for a point of clarification, when we are looking at the violations, we're looking at the governing body itself. If there is something that an employee has done that is for that governing board or that supervisor of that individual to address that. And that's why I had asked you the question of whether there was any indication that the governing body had invited this behavior from the employee. Is there anything else you'd like to add about the governing body and its actions when this occurred?
I can't speak to that because I was outside, not in the executive session.
I guess I was looking to clarify, when you say you're outside, are you outside of the room but still within the building where the open meeting is being held, or are you kicked outside the building completely if you're not a member of the board or this specific finance officer?
You're outside the building completely.
And is that where the public remains until they come out of executive session and they say, okay, public, now we're back into the open meeting portion. You're welcome to come back in for any additional motions we might make?
Correct.
Any other questions? Hearing no other questions for Ms. Hinsvark, again, I'm going to open up an opportunity for a response from the City of Gary, City Council. Hearing none, at this time we will move back into deliberations. Council? Commission, rather?
This is Austin Hoffman. I can very much understand where Mrs. Hinsbark's concern comes from. They're supposed to be closed, you could say private executive sessions. If somebody is sitting close to the door and listening, that's a concern. However, I don't see anything, I mean, we talk about this often, we're ultimately bound by the statutes that we have, where we only have authority that the statutes give us. And on the statutes that we have before us, I don't believe that there is a violation there. This is certainly something I think that we could look at on the task force side of things in the future. But what I see this coming down to is an issue that the council needs to handle with the city manager, and probably have her be a little farther away from the room when she's not participating in executive session. But I don't see it as a violation of our open meeting laws.
I agree with Mr. Hoffman. I think it's more of like a shame on the board for not doing a better job of setting the boundaries of where they want this finance officer to be if she's not included but rather excluded from their closed meeting. But I don't believe that it rises to the level of a violation here.
Any further discussion?
This is Mr. Russell. I tended to agree that the facts may not have been properly developed during this hearing as to exactly what had occurred. The concern that I have is that it appeared that the attorney for the city had acquiesced in a stipulation that they had in fact violated the statute. And the attorney not being present at this time, maybe because of the manner in which that we've handled this situation, may, quite frankly, not allow us to have adequate information to make the determination at this time. So, although I do not believe that the facts have been sufficiently developed, there certainly appears to be facts, according to the city attorney, in his mind, that allowed him to sign that he had in fact violated, or that the city had violated the statute. And therefore, I don't know that we have sufficient information to make a determination at this time.
Are you proposing that you would like to see someone motion to have it tabled to the next meeting?
Well, I think that might be advisable under the circumstances, just so that we could get a little bit, flesh this out a little bit better as to why the city believed that they were in fact in violation of the statute, and apparently our own council did also.
And I'm terrible at announcing myself. It was Emily Sovell that had asked the question of whether you were proposing it be tabled. I don't know if it's necessarily tabling or a continuation of the hearing itself. It's probably a continuation.
Likely a continuation. I think we would need a motion on that to effectuate that. I understand Mr. Russell's point. I do believe a full investigation was completed. The best I can tell, I'm not sure we were missing anything. Contrary to what's going to be 8D, I do believe that we're missing information there. However, we have a stipulation, and I don't want to get ahead of ourselves. I'm not sure if there's additional information that we could gather, and if we were inclined to continue this, would it ultimately be with a request to send it back to the complainant and the state's attorney for further investigation? Or is there anything else missing?
Well, this is Mr. Russell again. I'm reluctant to make any kind of a motion. I obviously am in the minority probably on the thought process here, but I just want to make sure that we've fully fleshed out what the situation is and have maybe the city attorney participating before we make some kind of a decision here. Because obviously there was, based upon the stipulation, there certainly was an acquiescence that the city was in violation of the statute. And I from what I can gather, and I've asked some questions that have kind of been objected to by the other members of the commission, as to the questioning of our council, as to the validity of the stipulation or the violation. I think that we probably should vet this just a little bit more, but I will leave that to the other members as to if they want to have any further information on this particular matter.
And maybe I spoke too quickly and tried to cut off our counsel, and she ultimately advises us. So maybe it's more of a chairman's request, but I think if Ms. Kotz has something more that would be helpful to us, certainly we're here to listen.
I would agree.
I don't, Beverly Kotz, I don't have anything more. I think continuing this hearing is probably appropriate.
All right, at this time, is anyone inclined to make a motion or any further discussion?
Lance, if you want to make the motion, I'd second it. I'm not opposed to that. Hearing from the city attorney, it's not a bad idea.
Then under that circumstance, so moved.
Hoffman seconds.
We have a motion and a second to continue this hearing. Any further discussion? The only thing I would add is I think that you make a great point in that the city attorney believed that this stipulation was going to be signed, and now with where we've been at, it does seem advisable and prudent to allow the city attorney to have an opportunity to be heard given where we're currently at. Hearing no other discussion, all those in favor indicate by saying aye.
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 All those opposed? Motion passes. Okay, so what that means ultimately is we will, prior to adjourning this meeting here, for anyone who's interested, I assume Ms. Hinsvark, providing mostly detail and information to you, is at the end of our presentations here. We have two other matters to address. We're going to have a discussion regarding future meetings. This will be heard at the next meeting of this commission, which has tended to meet roughly about twice a year since I've been on this commission, just as an FYI. At this time, then, we will move on to 8D, which is in the manner of the open meeting complaint 2026-03, City of Eagan City Board of Trustees, and I will also turn this over to Ms. Kotz.
Thank you, Beverly Kotz. In the matter of the open meetings complaint against the City of Eagan Board of Trustees, Moody County, OMC 2026-3, stipulation and agreement with reprimand. The stipulation and agreement with reprimand is made and entered into by the South Dakota Open Meetings Commission, hereinafter referred to as OMC, and the City of Eagan Board of Trustees witness and agree to the following. Number one, on November 24th, 2025, the Attorney General's Office on behalf of the OMC received a complaint from Michelle Tenek and Jerome Olson, which complaint was forwarded to the Moody County State's Attorney Paul Lewis to review and take action. Number two, on February 19th, Moody February 19, 2026, Moody County State's Attorney Paul Lewis referred the matter to the Attorney General's office for the OMC to hear the matter in accordance with SCCL 1-25-6 subsection 3. Number 3, the complainants made numerous allegations of violations of the open meetings laws against the City of Eagan City Board of Trustees, which are summarized in the attached Exhibit A, entitled New Additional Complaints, and the previous complaints contained therein. Number 4, the City of Eagan Board of Trustees understands they have the right to consult with an attorney of their choosing and expense, and did so with Counsel Reed Melky. The City of Eagan Board of Trustees understands they have a right to an administrative hearing. The City Attorney Reed Melky and the City Trustee Chair Cody Chamblin have been authorized to sign the stipulation and agreement are waiving the board's right to a hearing. Number 5, the City of Eagan Board of Trustees admits to the open meetings laws violations relating to the agenda not being posted on their website at least 24 hours before the meeting, and there was no timely publishing of minutes, both concerning the January 7th, 2026 meeting. Number 6, a copy of the open meetings brochure dated December 31st, 2025 was provided and explained to the City of Eagan Board of Trustees at the April 16th, 2026 Board of Trustees meeting by City Attorney Reed Melky, and the City of Eagan Board of Trustees acknowledge and receive and review the same. Number 7, the City of Eagan Board of Trustees, as the governing body of the City of Eagan, South Dakota, is a public body subject to the open meetings requirements of SDCL Chapter 1-25. Number 8, the City of Eagan Board of Trustees admits, and the OMC concludes, the City of Eagan Board of Trustees did violate the open meetings law by failing to properly post the agenda 24 hours before the meeting on the website and failed to timely publish minutes of the January 7, 2026 meeting as required by SDCL 1-25-1.1. Number 9, it is the intent of the City of Eagan Board of Trustees to provide an offer of an informal compromise and settlement of all issues which could be raised in a formal contested hearing. Number 10, this stipulation and agreement is a public record of the OMC and shall be published on the OMC's website. Number 11, this stipulation and agreement is subject to the Open Meetings Commission approval. In the event the Open Meetings Commission does not approve the stipulation and agreement, the OMC will proceed to hear this matter, and any argument is waived that the Open Meetings Commission members considering the stipulation agreement should be disqualified from later rendering a decision in a subsequent contested case hearing regarding this pending action, dated this 23rd day of April 2026. I'm sorry. Findings of facts, conclusions of law are hereby waived. Signed, Cody Chamblin, Board of Trustees Chair, and signed, Reed Melky, Attorney for the City of Eagan Board of Trustees. The next section, reprimand. Based on the foregoing, the South Dakota Open Meetings Commission reprimands the City of Eagan Board of Trustees for violating SDCL 1-25-1.1 by failing to properly post the agenda and publish minutes of the January 7th, 2026 meeting. And then it's a signature and the commissioner's appearance and vote. I'll turn it back over to Chairman Smith.
Thank you, Ms. Kotz. At this time, it'd be my intention to open this up to oral presentations, given how we've handled both 8B and 8C. I do see that Michelle Tenike was present and has left. Is any...
No, I'm still here.
You are?
I'm here.
Okay, great.
Yes.
So is it Tenike, is that correct?
Yes, that is correct.
Okay, and we have Ms. Tenike and Jerome Olson. Is he present?
Jerome sometimes is kind of hard of hearing, so I don't know if he can hear you very well or not.
Understood. At this point, it would be my intention to allow you the opportunity for what we, is an oral presentation. Understanding that there is this signed stipulation and agreement, we would like to give you an opportunity though, given, this commission has ultimately decided both in the matters involving the city of Gary not to adopt those, and instead to make our own motions after an opportunity to be heard. Would you like to take this time as the complainant to make a statement, ma'am?
Yes, I would.
So we will provide you with the 15 minutes. Ms. Kotz, will you alert her when there are 5 minutes left on your 15-minute timer? You may reserve a portion of the 15 minutes for rebuttal in the event that the city of Eagan also has an oral presentation. And with that, Ms. Tenike, if you don't have any questions, you may begin.
Okay, Jerome Olson and myself are on the city council board, and these violations have been going on, not just this one instance, but multiple. My bigger concern comes from the stipulation when it was discussed was, the board would agree to the stipulation and to be sent in. However, there's a lot of things in the complaint that are open meeting violations that are not in the stipulation. And so I don't feel that the stipulation is true and correct if they're only agreeing to failing to post agendas and minutes when there's multiple violations where they're making decisions outside of meetings, they have forums outside of meetings, and I don't have the complaint sitting in front of me. I'm traveling right now, so I apologize for that. I was ill prepared here. However, I think this warrants a deeper look at all the complaints that are on there, not just isolating it down to 1, 2, or 3 of them. There were 32 complaints. Some of them don't fall within the open meeting piece of it, but multiple of them do. So that's where I'm coming from on this. Is I don't think that stipulation was accurately represented, both to the board or to you guys, because they're only stipulating to a couple things. So that's what I have.
Thank you, ma'am. Any questions for Ms. Tenike? Hearing none, is the City of Eagan City Board of Trustees, is anyone present on behalf of the City of Eagan? I would note that it appears to be the same attorney that represented the City of Gary as well. Anyone present, though, on behalf of the City of Eagan? Hearing none, I would open the floor to the commission for deliberations.
If we were allowing the previous to be continued for that attorney, and with the fact that he likely or may have deemed his presence unnecessary, I think I would I would think we should discuss treating this the same way with a continuation.
This is Austin Hoffman. I would agree with that. Ultimately, I think there's 2 things that need to be taken into account here. The first, same as the other ones, I don't believe we have the authority to enter into a stipulation agreement. Number 2, if we're not going to do that, we should probably have the city attorney here to be able to at least give them the opportunity to be heard.
I don't have a complaint with that either. I would add, under 125.7, the Open Meeting Commission shall examine the complaint and investigatory file submitted by the state's attorney. I do not believe there's an investigatory file submitted by the state's attorney, which also gives me pause.
This is Austin. Was this the one that was submitted directly to the Attorney General's office?
This is Beverly Kotz. Yes, it was submitted directly to the Attorney General's office. I referred the matter to Paul Lewis, the state's attorney. I did not see when he sent the letter back referring this to the Open Meetings Commission, that an investigation had been done at all.
If I could clarify that for everybody, possibly.
And is this Ms. Tenike?
Yes, this is Ms. Tenike. I'm sorry. We submitted in November to the Attorney General's office because I wasn't sure of the process. They referred it back to Mr. Lewis. Nothing happened. Then I believe it was like January or so, we resubmitted with additional complaints, both to Mr. Lewis as well as Mr. Jackley's office. And then there was a timeline given for Mr. Lewis, and he exceeded that timeline for investigation. And then Mr. Jackley's office contacted him again, and his response was, "I'm just sending it to the commission." And so that's how we ended up. But we did submit it directly to him on the second go around by certified mail.
Thank you for that. This is Michael Smith. I'm reading again in 125.7, I believe it's the second sentence. It reads, based on the investigatory file submitted by the state's attorney or the attorney general. Here, the complaint comes from the state's attorney. So based on the investigatory file submitted by the state's attorney or the attorney general, in any written responses, the commission shall issue a written determination. I'm not confident personally moving forward without more investigatory file. I don't believe we have anything that I could even say constitutes an investigatory file, and whether or not that is ultimately collected through the state's attorney or the attorney general, I think the statute permits either, but the complaint was ultimately gets to this commission through the state's attorney. As I read through it, I see just the signed document by the state's attorney. I see the complaint, which is notarized by both Ms. Tenike and Mr. Olson, and appears to be really just attachments by the complainants regarding the conduct. Is that, Ms. Cox, is that accurate?
Yes.
Continuation of this, shall it be sent back?
Does anybody feel any different? That would be my concern. I mean, I feel as if this ultimately isn't ready, even statutorily, to be heard by this commission without that investigation.
And I would agree with that, and I want to add a few things in there as well. And I understand where this is coming from, but there's multiple complaints in here that frankly we don't have any authority over. Looking at 9-14, and I know I thought I saw another one as well. Maybe I'm incorrect on that, but there's 1-27. I think that needs to be kind of parsed out probably by the state's attorney at the local level, so that we're only really focusing on what may or may not be an actual violation.
I agree.
I also agree. This is Emily Settle.
With that, is there any further discussion? And if not, is anyone inclined to make a motion at this time?
This is Austin Hoffman. I will make a motion to refer this complaint back to the Moody County State's Attorney and politely ask that a full investigation is completed and presented to this board at a further date.
This is Emily Settle, and I would just, as comment to that, say, if he is inclined within his discretion to refer it back after he has the investigative report before him.
Austin Hoffman again. I would add the discretionary language onto that, because at the end of the day it is discretionary at the state's attorney level.
With that addition, Settle will second.
There's a motion and a second. Any further discussion? Hearing none, all those in favor indicate by saying aye. Aye.
Aye.
Aye.
Opposed? Motion passes. At At this point now, we will return back to what's listed on the agenda as 8A. It's in the matter of the open meetings complaint 2025-05, Town of Hermosa, Town Board of Trustees. And before I get any further, does anyone have a need to take a break, or this is the last substantive item? Power through? Okay. It's been an hour and a half. I didn't want to.
I still got coffee left, so we're good.
Good deal. I ran out. Then at this point, I'm going to open oral presentations. The complainant in this matter is a Vicki Henriksen. Ms. Henriksen, are you present? Ms. Henriksen does not appear to be present. She was not present when we originally got to this matter, which was at this point probably more than an hour ago. Ms. Kotz has indicated that through discussion with her that she did indicate that she would avail herself. Did she indicate whether or not she'd be appearing via Teams or in person?
She indicated that she would not be present due to a disability, that she would be appearing remotely.
Understood. And at this time, it is now almost 11:30 a.m. This meeting was properly noticed to begin at 10 a.m. We're now an hour and a half into this meeting. Ms. Henriksen is not present. With that, I'm going to next ask if anyone from the Town of Hermosa Town Board of Trustees is present and would like to make an oral presentation to the commission. Hearing none, I'm going to open this up to the commission for deliberations.
This particular matter, this is Emily Seville speaking. The letter from council says, quote, "It is clear that the actions of the board on this date violate the specific requirements of SDCL 125.1.1. And it continues on, after all, if a board could simply meet earlier than the announced agenda, it would defeat the purpose of the statute, which is to give citizens the ability to participate in the civic governance of their communities." It does not appear that they were contesting. There's comments on mitigation and things that they're going to correct their actions, and that's exactly what we like to see as a board. But without any other evidence, I think we rely on the complaint and the response from council, and to me, I don't think there's any question that we have a violation.
Any further discussion, or would someone be inclined to make a motion?
I will make a motion that we find a violation and that the appropriate reprimand be instituted.
Hoffman would second.
Any further discussion?
I would just like to, I'm thankful that they realize there's an issue here, but just so we have a record of it, one of the main reasons that we have posted agendas with times and places is so that the public can participate in these meetings. It's extremely worrisome to me if we have a council, committee, commission, whatever it may be out there that is holding a quote-unquote work session beforehand without any kind of notice and the public not being able to participate. I'm glad they realize the issues, and I'm hopeful that it will not happen again, but I certainly let this be a lesson to anybody else if this kind of action may be going on somewhere else. It absolutely is not permitted.
Thank you, Mr. Hoffman. Any further statements?
This is Mr. Russell. I just want to thank Mr. James for the letter he submitted on behalf of the town of Hermosa. And he outlined how he is going to try and make sure that this doesn't happen again. And I felt that they were very contrite, very open, and looking forward. And so I'm just thankful for his letter. I thought that it was very well organized and very well done.
Okay, we do have a motion and a second. At this time, if there's no further discussion, And hearing none, all those in favor indicate by saying aye.
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 Opposed? Motion passes. At this point, we'll move to the last agenda item, which is adjournment and discussion regarding future meeting, which we better do in opposite order. So discussion regarding future meeting, we now know that we have 2 complaints, although one was sent back for investigation, but possibly coming back to this commission. Ms. Kotz, are there any other complaints that you're aware of at this point?
Beverly Kotz. I did get one by email today, so yes.
Okay. It is end of April. I know that Mr. Hoffman and I serve on the task force as well, the Open Meetings Task Force. We're planning to meet again in August. I think that we can do this a couple of different ways, right? I think traditionally we've adjourned and kind of had a discussion before adjournment regarding kind of when people expect to be somewhat available, and then schedule it through email with Ms. Kotz. That would be my intention at this time. Of course, getting 5 of us all free is never easy. I would say that, of course, summertime is always challenging for me, and I imagine that most of you echo that sentiment. Is there a time frame, though, that other members are looking at that they would make themselves available, understanding that now it seems as if we have 2 for sure that we need to hear, 1 that's going to be investigated, and who knows what else could come in.
For those that are on the task force, you come out in person and you're meeting here in Pierre.
We do.
You know, I'm not opposed to consolidate if it's easier for you to be traveling out and 2 birds, 1 stone. It's a little faster maybe than we coordinate our meetings. I'm only 30 miles away though, so I should let others who are traveling further chime in on that.
The date for the next task force meeting is the 17th of August. I don't know if we want, the thing there as well, this morning we're done in about 1 hour and 40 minutes here. There have been times we've gone longer. Both task force meetings have gone into the afternoon.
We did move it up to 9 a.m.
That's right, we are starting earlier.
But you're right, they have been hours-long meetings, and I expect that the next one will be as well.
We're gonna ultimately try to finalize everything to get it ready to give to the AG's office for final consideration before proposing it for legislation. So that one I like the idea, don't get me wrong, we can save a few miles. I just don't know if that's gonna be possible.
That's fair. So maybe we like the idea of going back to the emailing and she can herd the cats accordingly.
And I would say, once I've got young kids, I think a chunk of us here do, it might be generally once school is back in session, things somewhat start to normalize to some degree.
Really?
To some degree. At least I'm usually in town and around. I'm not all over the place. I like the idea as well, but I think it would probably turn into, I think an August meeting would likely have to be scheduled for August 18th, which would mean 2 full days at Pier, which also not having to return a 4-hour drive. I don't hate, maybe let's at least, I don't know what your schedule is.
I wouldn't have a problem if we would, look at the 18th as a possibility, and then that still saves a drive as well for myself. Yeah, I'm not opposed to that.
I do have regular magistrate court on the 18th. It's in the afternoon, but I could try to appear by Zoom if you're planning on doing it in the morning. 17th in the afternoon, I'd be open.
Maybe we'll just give some thought to that, see what the agenda looks like for the 17th as well, and then over the next month or so, we can hopefully try to pin down a time frame.
Okay, so it'll be open tentatively targeting August 17th or August 18th or whatever fits the schedules.
After that, yes, I think that'd be great. Okay, anything else on the discussion regarding future meetings?
As to future meetings, I think that we probably should put on, and maybe this is for the task force more, to discuss the idea of whether we have some type of a template admission or template, something to expedite. I'm not opposed to going down the road that we're starting on, but I think we need to have a very clear procedure set for that, so maybe that's something we could add for discussion or for the task force to take a look at.
I put that in my notes to talk about. I'm not opposed to the idea of having some kind of agreement being made between the parties. My concern there, though, is I think if we're going to have the kind of stipulation and agreement, just shoot from the hip, I think the complainant needs to be a part of that as well, because they're obviously the ones that's bringing everything forward, and that could alleviate, having all parties as part of that, make the process smoother, quicker, simpler, all of the above, so.
I think if we would step in and be could approve the waiver of the hearing and approve the stipulation, but wouldn't necessarily be executing it.
Yep.
To stipulate to those facts.
And it's not uncommon, we even saw it with the Hermosa case today where there's an admission, and we've seen this before where responses include admissions. So having some way to work through it more efficiently, I think would be advantageous for us.
Maybe template forms or something like that say admissions by the respondent are as follows, A through whatever. So, okay, food for thought for future meetings.
Okay, then I would entertain a motion to adjourn.
Hoffman, so moved.
And second.
Second.
Brother Hoffman seconded. All those in favor indicate by saying aye.
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 Opposed? Motion passes. We are adjourned. Thank you all.